Okay, we've got 50 people on our attendance list now, so I think we'll start our webinar now. Welcome to our data tests and data protection. I'm Steve Cragg, and I head up our data protection and information law team. I'm going to chair today, but the main action is going to come from our two speakers from Data Street. That's Clare Duffy and Caroline Addy. Before I introduce them and the seminar, just a few words about the format this afternoon. You're viewing us on the Zoom webinar function, which means that we can see who's watching, but your details aren't shared more widely on the platform and you can't be seen or heard. We do have two functions for you to take part today. There's the chat function for general comments, which everyone else can see if you so choose. And then there's the Q&A function, which enables you to ask specific questions of the speakers. And we'll endeavour to have a Q&A session at the end. And this seminar is due to last for an hour. It's going to be recorded, and there will be slides available, both those you see this afternoon and others as well, and we'll make those available as soon as we can do. So the aim of this webinar is to tie in police powers in relation to retention and use of information in the context of policing and protests, with the relevant data protection laws now under the General Data Protection Regulation, the GDPR, and the Data Protection Act 2018, and that's what we're going to concentrate on today. So our two speakers, I'll just introduce those, introduce them both before we start. First of all, we have Clare Duffy. Clare joined Chambers in 2019 upon completion of her pupillage under the supervision of Jude Bunting, Ben Cooper QC, and Caroline. And she undertakes work in media and information law, inquests and actions against the police and public authorities. Prior to the bar, Clare worked in public policy and human rights, including working at the European Court of Human Rights, and taught public and administrative law at UCL. Second speaker is Caroline Addy. Caroline's also fairly recently joined Chambers, but she's very experienced at the bar with a broad practice in all areas of media, information law and human rights law. She acts for both claimants and defendants of all kinds, from private individuals to companies, and is a leading junior in Chambers and partners in the Legal 500 directories in defamation and privacy cases. So they're the ideal people to guide us through this topic this afternoon. Find out more about all of us on the Data Street web. Across to Clare. Thank you, Clare.
So it's actually across to Caroline first. Caroline?
Oh, it's Caroline first. Oh, all right. So I'm sorry about that. Yes, I should have read the screen. Thank you, Caroline. Sorry, getting mixed up. Which one you were doing it in? Let's go.
No problem at all. I want to talk about police information sharing today through the examples of two really rather different cases. But just in general terms, in terms of processing data for law enforcement purposes, we are in the realms of the Law Enforcement Directive, which was given domestic force by the Data Protection Act 2018 in Chapter 3. And all of these little snippets are going to be made available to you in slides. Unfortunately, they weren't ready in time, but very shortly today or tomorrow. So Chapter 3 includes general duties on the controller to make information available to data subjects, a right of access by the data subject, the usual, or rather the familiar rights to rectification, erasure, or restriction of processing on data, and the regulation of automated decision making. But Chapter 3 of the recent Act only applies in relation to the processing of personal data for a law enforcement purpose. In fact, police sharing arrangements are fairly commonplace, which may be surprising to some. There have been schemes such as Pub Watch and other things for quite a long time, but these have become far more formalised as data protection law has become stricter. Many local authorities operate a levy on the nighttime economy precisely to fund specific policing, including these kinds of information sharing initiatives. It's essentially circulation to specific local businesses, usually, of problematic citizens, if I can put it that way. You'll find a lot of useful information about police information sharing and the guidance that applies to it on the College of Policing website. And they make the following key points: that whereas if it's a national information sharing agreement, it has to follow the template which has been decided at senior level. If it's a local agreement, as was the case in the first authority we're going to look at, then local force procedures apply. But the fundamental principles are that sharing police information must be linked to a policing purpose. There must be a pressing social need to share information. Sharing information under statutory obligations doesn't require a specific agreement. So you use simply the statutory vehicle. Consent is problematic because it gives the data subject control over processing. So police services must seek consent only where strictly necessary and only where it cannot establish a policing purpose for processing. And obviously the purpose of that is to leave the police in control of what happens to data as far as possible. In the first case, which is R by her litigation friend M against the Chief Constable of Sussex and BCRP, in the relevant town, there was a business crime reduction programme, that's the BCRP, of local retailers and leisure businesses like pubs, clubs, etc. Very formal and well organised, which shared information with the police. So it was two-way sharing in relation to shoplifters, people who were violent and in other ways problematic. And the claimant was a vulnerable teenager, a frequent runaway and essentially a prolific petty criminal with many convictions for shoplifting and assault. And the issue in the action was that her full name, date of birth, photograph, criminal history, and also bail conditions were shared by police with the BCRP in her local area. It was disputed, but the court found that whether directly or indirectly, the police did also disclose that she was judged to be at risk of child sexual exploitation, and that was significant. So the two issues were in relation to the information sharing agreement between the police and the BCRP, in its different versions. Did the disclosures under the 2017 agreement between those parties breach the Data Protection Act 1998? And did the subsequent 2018 agreement between them conform to the provisions of the Data Protection Act 2018? One of the aspects of the case which I actually find surprising is that consideration of the facts was hampered by inadequate disclosure and very late disclosure by the police. And there was still a lack of certainty about precisely what was shared. I would have expected the lack of certainty in this context to come in for more criticism than it did. Fundamentally, the decision was that sharing the claimant's bail conditions didn't breach a relevant reporting restrictions order because the people in the information sharing scheme weren't members of the public in this context, that the police and the BCRP were joint data controllers, and that ultimately the combination of safeguards in the information sharing scheme was sufficient to comply with the 2018 Act. But as I say, there are a couple of reasons why I find that rather surprising. The information sharing scheme, the BCRP, had 500 members, which is a lot. So a large number of local businesses, some of which were branches of national chains, private security firms, pubs, bars, and nightclubs. And the main purpose of it was to be able to manage an exclusion notice scheme by which they would ban people from all the member businesses if they were found to be frequent offenders. One of the things that's surprising is that there was perhaps an insufficient concentration on the precise nature of the data that was shared. And as I say, that comes back to uncertainty because of lack of disclosure. The judge went into a lot of detail about the nature of the BCRP, and it was quite clear that conforming to the DPA, the ultimate finding, was dependent on the fact that there was so much in the way of formality and safeguards. So there was a particular board of management for the scheme. Not everybody, and certainly not every employee, was able to access information. In the event, the number of people found to be able to access the information shared was about 239. And of the people who had responsibility for administering the scheme, they were required to have a fairly high level of police vetting. And many of the other people who were able to access the scheme were security employees who had an SIA certification, which they would have lost had they misused the data. The particular concern of the claimant arose after she had been arrested again and was subjected to a reporting restrictions order, and then found that her information had been shared under the scheme, and by some means, which was not, I think, discovered, things like her bail conditions had been set out on social media. The arrangement was set out in a number of documents, the information sharing agreement itself, and a number of appendices and other agreements. And it became important to consider how appropriate the safeguards were when spread across a number of documents. There were particular constraints on the exchange of photographs, which could only be placed in the scheme after, say, 3 reports of antisocial behaviour in an 8-month period, or in the case of violent behaviour, 1 report in a similar period. And they were also restricted to people who had committed particular offences. One of the appendices to the information sharing agreement related to children, which was of course relevant to C, who was 16 when the case was brought. But it was essentially only concerned with when it would be correct to exclude children from member premises, rather than the approach to information sharing after an exclusion notice. And in that sense, it was viewed rather unfavourably by the court. Now, the evidence of the police was that they shared information on 5 occasions, and it was in the nature of, for example, that the claimant had been observed. These were reports rather than convictions, in assault or affray, observed in the act of breach of police bail, assault and stealing of a handbag, and so on. They denied that in fact they had disclosed any information that the claimant was a vulnerable child, and in particular that she was vulnerable to child sexual exploitation. However, they had identified her as being a person of interest in relation to a particular scheme, and it was known locally that that scheme related to young girls and women who were vulnerable in this way. So at least indirectly, they had informed the BCRP that she qualified under that designation. They also disclosed her status as a top 10 offender, in other words, that she was a person of particular focus in terms of crime prevention in the particular area. They argued, that is to say the police argued, that informing the BCRP partners of the claimant's bail conditions was lawful. Now, in terms of the court's findings, after a fairly detailed review of the law, which I think the judge rightly described as labyrinthine, it came down to a number of the following decisions. As I've said, sharing of the bail conditions ultimately was considered not to represent a breach of either the 98 or the 2018 Act. C had argued that the information sharing agreement couldn't be compliant because it failed to afford specific safeguards in relation to children and young people. There was nothing about their interests, merely about a related issue under Article 6F of the GDPR. And that effectively, that meant that the information sharing agreement breached Article 8. The court gave short shrift to the need or relevance to introduce Article 8 arguments, or indeed any arguments based on the UN Convention of the Rights of the Child. In particular, the judge felt that the various considerations that applied under Article 8 were essentially already inherent in the Data Protection Act and did not need to be considered separately. I don't think that's right in every case, but it probably made no difference in this one. It's interesting that the judge found that rather than the police being a data controller and the BCRP a recipient of the data as a processor, that, I'm quoting from paragraph 88, the much more natural reading of the situation was that the defendant was initially the data controller when it passed the data to BCRP, and then either they were joint data controllers or BCRP became a data controller on its own. In fact, the agreement described them as joint data controllers, and the judge thought that that was correct. She wasn't sure that that debate really mattered, but it might do, and I'll say a bit more about data controllers later on. The key question was whether the safeguards that one found in the agreements between the police and the BCRP were sufficient to meet the statutory requirements and to protect the claimant. And those really fell into the following categories: the nature of the data shared, the provisions about who it could be shared with, and control over any onward sharing, requirements for the training and vetting of recipients of the data, the degree to which the specific interests of children are factored into the proportionality exercise. And the judge went through all of those factors. She found that because of the number of different documents that had to be reviewed in order to understand the limitations of the scheme and its ambit, the limitation on the data was buried in a document to which there was only an opaque reference and which was actually drafted to deal with a different legal situation, namely GDPR. And that meant that essentially safeguards specific to children were unlikely to be effective. However, she felt this was mitigated by the fact that the only sensitive personal data, or special category data as we'd call it now, which could be shared was the photograph. And she considered it to be relevant that the photograph of the claimant was already widely disseminated through members' CCTV footage. Now, those safeguards weren't sufficient in themselves, but when the judge considered the other factors, she found that they were. As I've said, only 239 members of the Crime Reduction Partnership were entitled to have data shared with them, and the requirements as to training and vetting were very stringent. It was the joint responsibility of the police and the Crime Reduction Partnership in terms of any onward transmission of the information that they shared. There was also a secure intranet with appropriate safeguards. So notwithstanding the judge's concerns about the ambit of the agreement and how difficult it was fully to ascertain what the safeguards were in relation to children, she considered that overall, and taking into account the purposes of the agreement, which was public protection and the prevention of crime, and therefore the need for sharing with a fairly wide group, that was the relevant employees of the Crime Reduction Partnership, she considered that the sharing was proportionate and therefore the agreement was compliant. And in terms of the historical agreement, she concluded similarly. What I think is problematic about the decision is the failure of the judge to consider each category of data that was shared and to satisfy herself that there genuinely was an appropriate need to share that data. It's actually difficult to see what relevance the bail conditions of the claimant would have had, certainly to every member of the scheme. There may have been some who needed to see it, but that doesn't appear to have been particularly closely analysed. And as I say, the lack of certainty, the inability of either party to the agreement to set out for the court exactly what was shared and how, seems to have escaped criticism, which I find surprising. Now, the relevance of these agreements to protest could be significant. In terms of protest, certainly in London and the City of London, there is a fair amount of liaison and use of private security, which in the case of some of the larger city employees is quite sophisticated, at least on an eyes and ears basis with City of London Police and with the Metropolitan Police. Some of that may be done under urgency procedures, where sometimes for understandable reasons, the ability to conduct the right analysis may not be there. And there isn't, generally speaking, any transparency for members of the public in relation to some of these agreements unless they happen upon them, as the claimant did in M, to understand with whom the information is being shared and why. In Cooper and National Crime Agency, which is the second example I'd like to talk about, the circumstances were very, very different, because Mr. Cooper was an employee of the National Crime Agency who came a cropper on a night out in Hove and ended up being arrested for being drunk and disorderly in public and for assaulting a police officer. Now he himself immediately informed his line manager at the National Crime Agency as soon as he could. And unsurprisingly, the National Crime Agency called for all the arrest information from Sussex Police in order to assess what to do about Mr. Cooper. Ultimately, it decided that his arrest and charge was a serious breach of the relevant code of conduct, and Mr. Cooper was dismissed. That was upheld in the Employment Appeal Tribunal, but it was remitted back to the Employment Tribunal to give proper consideration to Mr. Cooper's case in relation to the relevance of data protection breaches. And Mr. Cooper also appealed his civil case in the county court against the refusal of the judge to award him damages for unlawful processing of his sensitive personal data. You have to admire the indefatigability, if that's the right word, of his counsel, because this was something of a kitchen sink case in which he did try very many different arguments in relation to why it had been unfair, first for the National Crime Agency to seek the data rather than, as he suggested they should, simply attend his trial when it happened to find out the conflicting narratives about the night of his arrest, requiring him to enter into the disciplinary proceedings based on that data before the criminal trial had concluded. The relevant decisions in what is a very detailed and actually very helpful judgment in terms of, in the Court of Appeal, I should say, in terms of the structure and the Act and how it is applied, were essentially these. The National Crime Agency became a data controller in respect of the Brighton arrest and custody material. As soon as it came into the National Crime Agency's possession, processing the Brighton custody information was necessary, and in this context that meant reasonably necessary, not absolutely necessary, as the least restrictive means of achieving a legitimate aim. Applying and enforcing the provisions of its employment contract with Mr. Cooper was essentially a part of the National Crime Agency's statutory functions. It had a compelling legitimate interest in processing the data in the manner that it did for its internal disciplinary proceedings, and it was in the public interest. It was not reasonable or in the public interest to expect it as employer to wait possibly for a very long time to find out what happened in the criminal proceedings. And it didn't breach the second data protection principle, that is to say the National Crime Agency, by using Mr. Cooper's data for a purpose which was different from that of Sussex Police in obtaining it. What was important in this action was why the National Crime Agency had obtained it and whether that was actually the purpose for which they ended up using it. Now, there were a number of interesting arguments in the action, including essentially before the ET, the suggestion that it could never be appropriate for a police force or a police employer to obtain information from another force and use it in disciplinary proceedings in this way. But by the time it came to the Court of Appeal, Mr. Cooper had, I think sensibly, softened his position somewhat. The court took note of the Information Commissioner's Office Data Sharing Code of Practice, which is a very useful document. Unfortunately, at the moment, it has still not been updated to apply to the, or to take account of the 2018 Act, in part because I think consultation is ongoing. So we only have the Code of Practice in relation to the old Act, which is of very limited use. The lawfulness of processing by the National Crime Agency was the key issue, and the court dismissed all suggestions that it had not been appropriate for the National Crime Agency to seek information from Sussex Police immediately. They considered that action as entirely unsurprising, and that it needed to obtain the information to assess whether Mr. Cooper had done something serious enough to merit further action, and if so, what. They considered it was similar to Lavity and Police Service for Northern Ireland, and couldn't sensibly be distinguished from that case, as Mr. Cooper argued. It made no difference that the agreement between the National Crime Agency and Mr. Cooper, on which the National Crime Agency relied, was a contract of employment and not a statutory instrument, as in the Northern Ireland case. Conformity with the relevant data protection principles was considered in turn, first, of course, lawful, fair and transparent, although the exception in section 35 of the DPA applied. And the judge found it not at all difficult, that is Lord Justice Sales, who gave the judgment of the court, to decide that it did. Most of the decisions in the case are fairly specific to the very particular employer-employee relationship of Mr. Cooper with the National Crime Agency. But the points of interest are when so the National Crime Agency became a data controller, and how the lawfulness of their actions as data controller was to be assessed. It was suggested that necessary in the relevant parts of the Data Protection Act must in this context mean absolutely necessary. But as I have said, that argument was completely rejected. To the extent that Mr. Cooper wanted to argue for broader privacy rights under Article 8, in contrast to the other case that I've mentioned, the court found that he should have raised it expressly and pleaded it. It's difficult, I think, in the time available to go through the very detailed arguments in Cooper. Beyond that, but one of the things I think that is interesting in both these cases is the readiness of the court to give a very broad leeway to police forces in relation to the sharing of data, where they are satisfied that the objectives and purposes of these schemes are legitimate. I've already mentioned how I consider that in the M case, the relevant police force, it's actually the same one, was given a very easy ride by the judge, notwithstanding that they weren't able to say in relation to that vulnerable person precisely what information they had shared. There was perhaps an even broader leeway given to the same police force in relation to Mr. Cooper's case, once the court had decided that the need for a speedy decision on disciplinary action, what form it should take, whether it should be made to await the criminal proceedings, was decided. One of the things that's also interesting in relation to both of these cases is the nature of becoming joint data controllers with partners to the information sharing agreements. The Article 29 Working Party gave an opinion on this in 2010 and said the concept of controller was a functional concept intended to allocate responsibilities where the factual influence is, and thus based on a factual rather than a formal analysis. And then it said they needed to ensure, the need to ensure effectiveness requires that a pragmatic approach is taken with a view to ensure predictability with regard to control. Well, at the moment, the court appears to take a very broad approach in which it's very ready to find that particular parties are joint controllers. And that includes cases in which, for example, a rogue employee has been given data from its employer to use for only one purpose and without, in fact, exercising any independent judgment or decision making. In a relatively recent case, an opinion of the Advocate General, which is the Fashion ID case, German fashion company, and an activist NGO, the fashion company had decided to put a Facebook button on its website so that people who were shopping for clothes could click the Facebook button, add likes and so on. Doing so immediately, well, in fact, you didn't even need to click the button. Having the button on the website immediately meant that your information was sent to Facebook. And in his opinion, the Advocate General asked, who then is not a joint controller? Because the company was a joint controller with Facebook, even though it had no idea what Facebook received and what it did with the information. It was a fairly passive partner in the arrangement. And he also asks, not unreasonably, will effective protection be enhanced if everyone is made responsible for ensuring it? It is, he suggests, a dilution of the status of data controller, which was meant to ensure compliance by fixing, in a predictable way, a specific party with responsibility under data protection legislation. he criticised the recent case law of the court, the European Court, as being very inclusive when asked to define in one way or another the notion of joint controller. And so far it hadn't faced the practical implications of such a sweeping definitional approach. Definitional, I beg your pardon. He pointed out, and this is relevant, I think, for litigators faced with police information sharing with parties like the BCRP, that the GDPR appeared to be introducing a new regime of joint liability in its Article 26. He thought that could turn into quite a challenge. On the one hand, Article 26.1 of the GDPR makes it possible for joint controllers to determine their respective responsibilities for compliance with the obligations. But on the other hand, Article 26.3 of the GDPR makes it clear that the data subject may exercise his or her rights in respect of and against each of the controllers, irrespective of any such arrangement. Therefore, you as data subject and litigant are not constrained by any agreement which makes, for example, the police and another party joint data controllers when assessing who it is that you wish to sue and in respect of what steps of processing. And that, I think, it is an extremely relevant consideration when meeting these ISA information sharing agreements. And I think, Stephen, that's all I wanted to say about information sharing.
Thank you, Caroline. Thank you very much.
Now,
should we move on to Clare, because I think we can run
sure.
out of time otherwise. Why don't we move on now?
Yes, if I can have the first slide.
Okay.
So my brief today is to discuss different aspects of data protection in relation to mass protests. I'm not going to cover automated facial recognition technology, which is being heard in the Court of Appeal today. I'm going to leave that to the brains in the Court of Appeal. Instead, I'm going to address two different topics. The first one is, in what circumstances can persons filming police officers in protests rely on the journalism exemption under data protection regime? And the second aspect I'm going to consider is how people can challenge the collection and retention of their data. And the reason I'm going to focus on that second one is, in recent protests, we've seen an uptick of policing techniques such as kettling and Section 60, which can lead to the collection indiscriminately of data from protesters, no matter what conduct they've actually done at the protest. So with that, I'm going to start with the citizen journalists. So if I can have my next slide. So the relevant case here is from Luxembourg, and it's of a Mr. Sergis Buivits, and because I've no doubt butchered his surname, I'm going to refer to him as Mr. B. So Mr. B had taken a film of police officers at a Latvian police station when he was making a statement in the context of administrative proceedings against him. That video showed the identities of the police officers, clearly showed their faces, and also audio of them going about their business. That was not in compliance with Latvian personal data protection law. And so the National Data Protection Agency requested Mr. B remove the video from YouTube. Mr. B challenged that request for him to remove the video by means of judicial review. And he had two contradictory arguments, one is which it fell under the personal household exemption, but it wasn't processing, didn't fall within the regime at all. And the second was that he was acting as a citizen journalist. And I'm just going to focus on that second one today. So the quote you can see on the screen was his argument in respect of the journalism exemption. He wished, by publishing the video, to bring to the attention of society something which he considered to constitute unlawful conduct on the part of the police. So if I can have my next slide. So in effect, he was trying to rely on Article 9 of Directive 1995/46, which is a precursor to the general GDPR. And that provided that processing of personal data, here the filming and uploading it onto YouTube, carried out solely for journalistic processes, you can be exempt from the requirements of the data protection regime if necessary to reconcile the right of privacy with the rules governing freedom of expression. So if I can have the next slide. There were two questions that bothered the court. The first one there I'm going to gloss over because it was largely uncontroversial. The recorded image identified or an identifiable natural person, that's personal data, and the recording of the footage and its subsequent publication was wholly or partly by automatic means. So if I could have the next slide. The answer to that was yes, and you can find that, sorry, go back to, you can find that in paragraph 47 of the judgment. Sorry, could you go back one slide? So the main question that the court bothered itself with was whether he could rely on the derogation for journalists under Article 9. And the answer was yes, in principle. So if we go on to the next slide. The courts took 4 steps of reasoning. So the first one is that Article 9 did not only apply to media undertakings, but to any person concerned in journalism. So you didn't need to hold a press card in order to benefit from the exemption under Article 9. Secondly, journalistic activities applies to any activities which has as a sole purpose the disclosure to the public of information, opinions, or ideas, irrespective of the means used to transmit them. Here, it didn't need to be published in a newspaper or broadcast on TV. Uploading to social media or a video sharing website is sufficient to constitute a journalistic activity. So thirdly, the Latvian, that was as far as the court went in prescribing what contracting parties had to look at. So you had to look at whether it was solely for journalistic activities, but the court suggested that the Latvian courts may want to look at other relevant factors. And the one they particularly highlighted was the fact that Mr. B published the video to draw attention to alleged police malpractice that took place. Crucially, the Latvian courts were expressly told Mr. B did not need to actually establish that alleged police malpractice occurred to benefit from Article 9. So it was enough that he felt that his rights in that situations were being infringed, and it was a matter for public debate whether or not malpractice had occurred. And then finally, and somewhat unexpectedly in the judgment, the court held that Article 9 only applied when strictly necessary to reconcile the right of privacy with the right to freedom of expression. And it set out various criteria by which a court could consider whether privacy or speech was weighted heavier in the balance. So some of those factors were the contribution to a debate of public interest, the degree of notoriety of the person affected, the subject of the journalistic activity, and the content and form and consequences of the publication. So drawing that together, if I could have the next slide, the test to be applied to someone who has uploaded a video taken at a protest would be, can they show that the sole reason they took the video and uploaded it on the internet was to disclose information, opinion, or ideas to the public? If they can satisfy that test on the facts, then they can be a citizen journalist and benefit from the journalist exemption. One thing that is quite interesting in this particular paragraph is what kinds of factors a court could look at to decide whether it's solely for journalistic process. So it needs to be uploaded to a website where users can send, watch, or share videos. In that respect, uploading it to a private Facebook page would not necessarily hit that criteria if restrictions on sharing the videos were turned off. Uploading it to something such as Twitter, by contrast, where users can readily retweet and like, would more readily fall within that underlined sentence. It also suggests that the court will look at the video itself. So so far as it is apparent from the video, that raises the question, how much will the court look at extraneous factors such as an article that went alongside the video, a description underneath the YouTube video. So there's a question of how much contextual information a court may take into account. And of course, the sole object needs to be the disclosure of information, opinions, or ideas to the public. So if somebody is uploading a video where they personally feel aggrieved, and there might be an element of vindication or wanting to share that with family and friends, that could be used to challenge whether the sole object was imparting information to the public at large. Is there a public interest in the disclosure and publication of the video? So turning on to the next slide. So from this judgment, two questions arise. Firstly, does the same apply under the GDPR and the Data Protection 2008 framework? In short, yes. So here you have the text of Article 9 of the directive, and on the next slide, there you have the text of Article 85. So it is pretty similar to a mirror provision. The underlined phrases solely and only are not contained in the GDPR. So it may be that Mr. B under the GDPR would have an easier threshold in showing that he was uploading a video for journalistic processes, and perhaps be able to have other motivations alongside the journalistic processes, as long as primarily it was to share information with the public at large. So this is where the element of vindicating yourself or your own experience that you had may not undermine the journalistic process. So on to the next slide. The second question that arises out of the case is, what are the implications for mass protests in the UK? And so here I have three implications. Firstly, and most obviously, it is a potentially helpful defence for observers or protesters who film police officers at the protest and then upload it to social media. Secondly, there are beneficial procedural hurdles for a defendant in a private action. So it could be a good way of warding off a data protection claim. Where a citizen journalist relies on the journalistic exemption, proceedings for private remedy will be forestalled by the requirement of the Information Commissioner to do a special determination of that journalistic exemption. So unless and until the Information Commissioner has made that special determination and all avenues against the Information Commissioner's decision have been exhausted, then proceedings for private remedy are placed in abeyance. So it might be raising journalist exemption as a defence might be a good way of stalling proceedings and potentially bringing them to some kind of settlement. And then finally, the judgment has important policy implications. So it's quite clear that you can film the police in Mr. B's context, in a police station, in the UK context, in mass protests. And so this feeds into the need for the police's identities to be visible at protests. So this has precedent with Ian Tomlinson dying in the G20 protest in 2009. The police officer who was involved in his death, his number on his shoulder was obscured by his high-vis jacket. And so it was difficult to determine which officers were involved. If citizens are allowed to film the identity of the police, that only increases the need for their identities to be readily available to protesters. And this is including in the context of COVID-19. So commissioners who've just given guidance to police saying that face coverings are not allowed even at at protests to enable them to better be identified to the protesters attending. So moving on to my second topic, which is data retention. If I could have the next slide. And the next. So this topic arises from police tactics that have been used in the Black Lives Matter protests. So the first one I have in mind is the use of kettling as potentially an evidence gathering tactic. And the second one I have in the mind is the use of Section 60 orders. So in terms of kettling, as I'm sure persons attending this webinar will be aware, between the 7th and 8th of June, protesters were held in Downing Street for 6 hours. And in order to be able to leave the kettle, the police photographed them, filmed them up and down, and asked them to provide their names. So that would be a mode by which the police would gather someone's data indiscriminately, irrespective of their conduct at the protest itself. Similarly, Section 60, which are no suspicion search powers, so the image on the right is the area imposed where the police no longer needed to have specific reasonable grounds for suspicion, meaning that a constable in uniform could stop and search any pedestrian for anything carried with them or their vehicle for offensive weapons or dangerous instruments. Again, removing the reasonable grounds for suspicion requirement could mean that data is collected more indiscriminately against certain demographics. So turning to the next slide, why does this matter? So mindful of the time, I'll go through this quite quickly, but this is an illustrative example of the retention of data of a protester based on his association with others at the protest rather than his own conduct. So Mr. Segeloff is a journalist, and he had attended a number of demonstrations, as you can see on the slide, anti-austerity demonstrations and protests against BNP in June 2014, and a protest against the Commissioner of the Met Police at Sussex University in 2015. Not on the slide is he was also present at a protest at a Byron Burgers restaurant where protesters released crickets and cockroaches into the restaurant, which is of course criminal damage. And he was in attendance, he said, as a journalist, but it went on his record. The police tried to justify why they'd retained that data, saying he did not intervene or walk away. So he was discredited by association. All this information taken together meant he was saved as an XLW, or an extreme left-wing activist, which would come as some surprise given the types of causes he was protesting against. If I could turn to the next slide. So the police were able to have the benefit of Section 29 of the DPA, which enables personal data to be processed for the prevention or detection of crime. And that removes the requirement for data to be processed, conditionally removes the requirement for data to be processed fairly and lawfully under the first data protection principle. Because Mr. Segeloff had an unpublished policy applied against him when he wanted to attend the Labour Party conference in Brighton by the two chief constable defendants, the police, that specific aspect of it was not for the prevention and detection of crime. And so the processing of his data and the saving of him on the system as an extreme left-wing activist was contrary to the Data Protection Act. The court also held obiter that it could have contravened two other data protection principles, so data protection principle number 3, which is that personal data shall be adequate, relevant, and not excessive, and personal data protection 4, which that the data should be accurate and, where necessary, kept up to date. But given a fact-finding exercise was required to investigate those two data protection principles, and the case was decided on other grounds, the court left it because the judicial review procedure was not well equipped for that fact-finding exercise. So the Sekulov case raises some questions for persons attending mass protests. Will they now be classed as extreme left-wing activists? Will their association with the protests where others commit criminal acts discredit them? If so, how do they find out? And how do they get that information removed from police databases? So moving on to my next slide. Sorry, and my next. Under the Data Protection Act 2018 and the Law Enforcement Directive 2016, a data subject has various rights. So they're listed there: the right of access, the right to rectification, the right to erasure, the right to restrict processing, and the right not to be subject to automated decision making. If you could have the next slide. For reasons of time, I'm just going to focus on two. So the right of access and the right to erasure. Next slide. So under the Data Protection Act, all data subjects have the right to access to their rights, to the information held on them by a data controller. That right of access is restricted by three factors, but before I address those, we can move to the next slide. So Article 14 sets out what kind of information they can access. So you will see its purposes of and the legal basis of processing, categories of data, the recipients to whom the personal data has been disclosed. So that could be another police force or a third party not in police force at all. The envisaged period for which it will be stored, and they also have to be informed of their rights to get rectification or erasure, and also to lodge a complaint. So if you go back to my former slide. So in this respect, I wanted to give some tips on how to apply for that right of access, bearing in mind the three restrictions. So the first thing, in order to access the data, there's no explicit formula set out in the Data Protection Act. The controller will need to know, you just need to write to the controller asking for them to access your data. However, the controller must refuse to give you the information under Article 14 if they have doubt about your identity, and the standard there is beyond reasonable doubt. So my first tip is to be clear about identity and ask the data controller to contact the data subject immediately should the data controller have any doubts about the identity of the data subject. And in that respect, you can draw the police's attention to section 52, subsection 4, subsection A of the Data Protection Act, which allows them to contact the data subject in order to get more information about their identity. The second tip would be to make it precise. So limit the date of the data you are requesting, either by a date range or, in the context of mass protests, by reference to the specific protest. You can also invite the data controller to ask the data subject to refine the request if they estimate compliance will impose an excessive amount of work. And this relates to the second restriction, which is the data controller may refuse to give access to the information if it is manifestly unfounded or excessive. And they can also request a reasonable fee for dealing with the access request. Finally, the data controller can refuse to provide the information if it, by relying on two provisions, I've got them wrong on the slide, it's Article 13.3 of the Law Enforcement Directions and sections 44, subsection 4 and 45, subsection 5 of the Data Protection Act. And under those provisions, a controller may restrict wholly or partly the provision of information to the data subject to the extent that, and for so long as, the restriction is a necessary and proportionate measure to, and it sets out 5 different categories, but it's to, one of which is to avoid prejudicing the prevention, detention, investigation or prosecution of criminal offences. And in so doing, they have to have regards to the fundamental rights and legitimate interests of the data subject. So clinging onto that subclause, having regard to the fundamental rights and legitimate interests of the data subject, it would be in the data subject's interest in the request to set out, if there's non-compliance, what loss, damage or distress they would incur, and spell that out together with precisely what kinds of loss and damage there would be, to focus the data controller's mind on consequences that could follow were they not to give the information that has been requested. And so on to the next slide, 2 slides. The other right I wanted to focus on was the right of erasure, and I'll deal with that even more briefly. So that's, you've got the provisions of the Data Protection Act and the Law Enforcement Directive in which it is located. The right to erasure is only exercisable if a data processing principle, either relating to personal data or the processing of sensitive personal data, has been infringed. So that makes the first step of access to the information really crucial in order to exercise the rights of erasure. In effect, the right of erasure will end the infringement of the data protection principles, and it requires the data controller to inform both the data subject of the erasure, but also to contact third parties that he shared the data with in order to ensure that it is erased there as well. And if the data controller refuses to erase the data, then the data subject can ask for reasons and lodge complaint either with the Information Commissioner or apply to the court for a compliance order. So that's my whistle-stop tour through 2 ways in which data protection can impact upon the rights of those attending or filming protests. So I think if we move 2 slides further forward, we move on to questions.
Sorry,
thank you very much, Claire.
before we do, could I just...
keep an eye on... Sorry, Caroline. Yeah,
Yes.
go ahead.
Before we do, because it ties in nicely with some of the things Claire's been talking about, just one mention of Bridges, which is in the Court of Appeal today, which was about, as we know, automated facial recognition. Mr. Bridges lost his case protesting the use of that because anyone not matching people on a watch list had their data immediately deleted. Looking at the judgment below today, it seemed to me that the court was very incurious about how the algorithm, the software, had learned to match human faces. And the reason I mention that is that I know it's part of protests in the US at the moment by people who've attended Black Lives Matter protests, that they say the police have to train the algorithm used in AFR by taking and retaining thousands of images to allow the software to learn matching. And I know in the South Wales Police pilot, over a year, apparently they captured 500,000 images, albeit that they say all of those were deleted. So it will just be interesting to see, in connection with indiscriminate photographs of people who've been kettled, whether in fact some of this is about helping the police AFR to learn how to match faces, and whether or not the Court of Appeal is going to explore that. Thanks. Sorry, I just wanted to add that point.
No, that's really important. I think that is one of the most important cases ongoing at the moment in the Court of Appeal today, I think for the next 3 days. And I think it's the courts also catching up with all this technology as well, and sometimes a bit overwhelmed as to how it works and what it's for. In the chat, I think we don't have any questions as such, and so I let the presentations go on till the end of the session. In the chat, Matthew Gold points out, I think the first case you were talking about, Caroline, was the M case. And Matthew Gold says he acts for M in that case, and they have permission to appeal to the Court of Appeal. So that would be a watch this space question there. So I think we've gone for our hour. Thank you, Caroline and Claire, for two fantastic presentations. I think it's really interesting to look at police powers of that lens, and I'm sure there's a lot more we can all do about that and around that area, and using those pieces of legislation as well in times to come. So I'm going to wrap up the session now and thank both Caroline and Claire for their presentations. If you want to know more, then we're all available to discuss anything which has arisen in the sessions today. The session has been recorded, and there will be slides and recording available as soon as we can do that. So thank you all, and hopefully we'll see you all again very soon for another Dove Street webinar. Thank you. Goodbye.